Good afternoon. This is Talib Kareem, Legal Director at Abe.
Hey, I'm Brendan Nichols. I'm the Abe Chief Operating Officer.
And today we're thrilled to announce the launch of Abe for Business. This new product allows small to medium-sized businesses and nonprofits to get the benefit of having a lawyer on call and actually on retainer at a much more affordable price. And also, I believe, in a team approach. So instead of just having one lawyer to take care of your legal matters, you can get a whole team at the cost of less than what one lawyer at a large or medium-sized law firm would charge. And so one of the benefits of becoming an Abe user is the ability to get content such as this video that we're launching today, discussing the cutting-edge issues that affect small to medium-sized businesses and nonprofit organizations. And our first conversation topic is going to be focused on the Digital Millennium Copyright Act. Now, why is the Digital Millennium Copyright Act important to you as a business owner, a nonprofit executive, or an entrepreneur? And to answer that, let me turn it over to Brendan.
So I want to just give a little background about the Digital Millennium Copyright Act. It's called the DMCA. No one refers to it by its full name. And it was signed into law in '98 by Bill Clinton, pretty much unanimously passed by the House and the Senate. It was not controversial at the time. It's really thought of as, when at that point, the anti-Napster bill. It was meant to combat people essentially stealing people's music, putting it on the internet so other people could download it. Which what they then is now called torrenting, but back then was just sharing it via LimeWire or Napster or many of those things. So the basic elements of it when it was established were to have a Digital Millennium DMCA complaint. You had to have ownership of a copyright. Someone had to circumvent a technological measure designed to protect the copyrighted material, and that technological measure didn't need to be much. It can be as simple as making something non-downloadable. If you open up a third-party app to download a video on YouTube that's marked as non-downloadable, that's technological circumvention. Unauthorized access by third parties, that means the person who took it did not have your consent to take it. Infringement because of the circumvention of that technological measure, and that's just your copyright infringement. Essentially, they took it. And the circumvention was achieved through software that attended either designed or produced primarily for the circumvention. That's Napster. That's literally what Napster was. It was designed to circumvent the protections on users, artists, and the studios that produced the songs, and made available despite only limited commercial significance other than circumventions, and marketed for use in circumventions of the controlling technological measure. This is your torrenting now. This was your Napster back in the 90s. Torrenting, it gets away for this largely because it's all hosted overseas, so it's very difficult to gain access to the people who are hosting this. But those are more issues that are fun from a historical perspective. The real issue that's going on today with the DMCA is DMCA was expanded in the 2000s to allow people individuals who own the copyright to file complaints against web hosts. This is the way that you see things that said this video was taken down or this picture is no longer available, things like that. It's because the holders of the copyright are now allowed to petition the web hosts, and this is organizations like WordPress, Facebook, Twitter, even Google Search. All sorts of other Amazon Web Services, anything that hosts this content, the owner of that copyright is allowed to go to them, and all they have to do is file a notice giving what is infringing, where it is, and then they have to take it down. The notice has to be filed in good faith, and the information in the notice has to be accurate. And under the penalty of perjury, the originator is entitled to act on behalf of somebody who owns an exclusive right. That is a copyright. So essentially, you can have your lawyer file the complaint. You don't have to do it yourself. But the problem, and there's many problems with this, and we'll get into the difficulty, but really some later. But really what the biggest issue is for both people who file these complaints and people who have to respond to them is it's so easy to file a complaint. you can pretty much file a complaint on anything, and then Google or Facebook or Twitter, they're just going to take it down immediately. And the person who, even if they weren't technically infringing on the DMCA, they have to appeal that complaint to a legal authority, to the courts essentially, to get it restored. And the appeal process is much more difficult.
So it seems to me that the companies and nonprofits who really are affected by DMCA would be those who are involved, let's say, in producing video content like video blogs or even podcasts,
music,
or
podcasts,
either even
art,
performances.
yeah,
right?
performance.
So those are the most likely people who are going to really want to pay attention to the DMCA. But you would be surprised because the case we're going to talk about actually involves companies that you probably would not even think about in the context of DMCA, and that are two oil production-related companies, right? What does DMCA have to do with oil production, you might ask, right? Well, in this case, you had a company involved with fracking. I think most of you all know fracking involves the transmission of pressurized water into the earth that will help to essentially pump out oil out of caverns within the earth that are heretofore not able to be reached by your traditional well, which goes directly down. So these fracking mechanisms use the water and again allow the extraction of the oil to come out much easier than heretofore use the traditional drilling, or not drilling, but yeah, traditional drilling. Well, so in this case, there's a case that is specifically the case of Diamondback Industries, which again was a fracker, versus Repeat Precision. And in this case, Repeat Precision is a tool manufacturer. They manufacture essentially plugs that are involved in the fracking process. So what happened in this case was actually Repeat Precision sued Diamondback because it alleged that Diamondback had essentially downloaded its copyrighted materials and stolen it. And of course, Diamondback disagreed and basically appealed the decision in favor of Repeat. And that's the case that we're going to be dealing with today. Now, Brennan, tell us first of all what happened in the underlying case, and then what happened in the second case.
So in the underlying case here, essentially the Diamondback alleged that Repeat Precision had taken their.
I think it was the opposite. So I think that what happened was Repeat sued Diamondback, but then appealed, and that's the reason why the.
So Repeat must have sued Diamondback for this, essentially taking this under the DMCA, and Repeat won actually in their. Repeat lost their lawsuit, and the reason they lost it because it was held that because Repeat had not actually registered their copyright for these documents that Diamondback Industries had taken, that the DMCA did not apply. It wasn't under the first prong of the DMCA, you remember, a copyrighted article. Now, when they appealed, that Diamondback Industries said that doesn't matter. We still own the copyright, even though we haven't registered it with the U.S. Copyright and Patent Office. You still own a copyright as soon as you create something. Registering it just gives you some additional protections, makes it easier to protect your copyrighted material, and makes it easier to win any court case, as this court case demonstrates. So again, if you are creating copyrightable material, you should definitely look into getting a lawyer. Call us at Abe or go to abe.legal to find a lawyer to help you register your trademark, patent, or copyright with the U.S. Copyright and Patent Office. But then, at the end of the day, the judge decided that the original ruling was wrong, that just because the DMCA calls for a copyrighted material, it did not specify that the copyrighted material must be registered with the U.S. federal government. So Diamondback ended up winning, and they got to keep their own proprietary software, and there were some damages.
I thought the Precision was the one that was that the owner Precision that the supplier that acquired the company. Oh, so essentially one was trying to actually acquire the company, right?
Mm-hmm.
So Repeat was trying to acquire Diamondback. And the reason why, as you were saying, the Diamondback sued successfully was that Diamondback argued that essentially this attempt to acquire was just a ploy to basically get confidential access to its copyrightable and protected materials, particularly the designs relating to the equipment that the Diamondback. So you were absolutely right in terms of the prescription there, and this goes back to show you that again. You may think that if I'm not in for example, the theatrical performance industry, or I'm not doing a blog, or I'm not doing a podcast, that maybe I don't have anything to worry about with the Digital Millennium Copyright Act. Well, this case shows that you do. That if you have essentially secret or confidential materials, let's say contacts to board members or contacts to customers, or you have designs that you have access to, or you have developed business ideas that you haven't yet released to the public. Well, all of that could be protected by the Copyright Act, and particularly the Digital Millennium Copyright Act. And so, therefore, you do need to, again, think about how a lawyer, and particularly a team of lawyers, such as those that we have available here with Abe, can assist you. And that's the reason why we have launched our platform that is available at www.abe.legal, and or you can give us a call as well. But generally, the best way of reaching us day or night is through the website. So, Brendan, let's go into a question.
Oh, well, first I want to talk about the more common issue you're going to have with the DMCA for small business owners and nonprofits.
Let's go for it.
And so the big issue you're going to have all the time is if you are aggregating any sort of content from other people, you're going to get DMCA complaints filed against you. And if you get one filed against you, they're automatically going to be taken down on the hosting service you use, whatnot. Unless you're literally having a server in your own home and you're using that, the company is going to host your product, that hosts the search engine, is going to have to take down whatever is being alleged as infringed against the DMCA.
So let me ask you a question. So, for example, let's say if you had a small newspaper that wrote something negative about you, and you believe that you argue that their publication of the information about you is a violation of the DMCA, and you send that to, let's say, Google. Are you saying that Google will take that down?
Google will take it down. The newspaper on that hand could sue you to get it put back. They could also sue you for damages because it's a bad faith, and you could be criminally prosecuted if you do something for perjury.
What? Well, I mean, what you wouldn't be perjuring yourself by communicating it to Google, because they're not a court. So perjury is only basically
it would be making a statement before the law
court.
Yeah, during the appeal.
Right. So basically.
No, actually, it is in fact perjury to file a non-good faith, or it's not perjury. It's illegal to file a DMCA complaint in bad faith.
Okay, so that's a part of the statute.
That's a part of the statute, and that's to prevent people from making frivolous complaints like that. Unfortunately, that is very lightly enforced. So in theory, it seems like a good idea, right? Because you don't want people doing it. But they did some studies where they found like 50% of DMCA complaints were one competitor targeting another competitor, just saying, they stole that from me, they stole that from me, they stole.
Right.
just over and over again. And it was a form of digital harassment, right?
Overly broad use.
And overly broad use.
And so again, this is another reason, sorry to cut you out, but you may need just to jump on a call with us. And if you do need to do that, don't hesitate to give us a call day or night, 24 hours a day, at 202-517-6982. That's 202-517-6982. You want to go to that question that we had from one of the folks that are out there in the ecosphere, if you will, the ecosystem, who likes to ask questions. We'll go to this question. So we have a question from someone in Virginia named Jake. And the question is that he sees DMCA complaints all the time on Google searches when he goes to do research, and even on Twitter. And oftentimes videos as a result of these complaints are taken down. Why? And I think you pointed out this a little bit in your analysis. But why is it that companies like Twitter don't push back? They just automatically take them down.
So, Jake, thanks for the question. They're required under law to take these things down immediately, within 24 hours, actually. Yeah. Right. And the reason they have this is because Twitter, YouTube, Google, they don't want to have to deal with scrubbing their own content people put on those platforms to see if everything's in compliance with the DMCA. They want the people who own the copyright, in this case the person filing the complaint, to have to tell them that this is in violation of our copyright and therefore you need to take it down. And they take it down, and they're required under the law to post that complaint about why it has been taken down, so that the person who put it up can essentially appeal the DMCA. Now, if this happens to you, and if you're a content producer who does things with sports or entertainment, uses images or videos or news clippings or whatnot, this could very easily happen to you. If you're running a blog, running a YouTube channel, then you get a DMCA complaint. And remember, it's super easy for companies to file these complaints, and so they do. And because they know the vast majority of people are not going to appeal, because appealing it is much harder than filing the complaint. That's why you need to call a lawyer if you have this complaint, and especially if you think it's going to harm your business. Because again, these companies file a complaint about everything. And there are a lot of exceptions to this rule. For example, there's the fair use doctrine, which allows the use of this for use of public images for criticism, comment, news reporting, teaching, scholarship, and research. There are a lot of sections to this. But the thing is, the companies don't care about that because they know that 99% of people are never going to appeal this TALB, so they just essentially win. They direct all of the traffic to them because they've taken it off the rest of the web.
So again, that's the reason why we've created this podcast and this video content for you to know exactly what to do when you are faced with such a challenge. And again, what should you do? Well, you can go and actually give us a call at 202-517-6982, or you can go and complete a central form to sign up to get a lawyer either on retainer or a team of lawyers on retainer to help you, or if you want to, again, jump on the call and have an in-depth conversation initially to get started, to basically determine whether you need a team of lawyers, we can actually absolutely help you with that as well. And that's at abe.legal, www.abe.legal. So this has been the video podcast for Abe. We look forward to talking with you more in the future, and signing out on a mild day in December in Washington, D.C.
All right. Thanks so much, guys. Till next week.